ladies and gentlemen, and I'm back with another one. This is Ramondeleon with Smoothoperationoflaw, and today I'm going to talk about the Trademark Counterfeiting Act of 1984. The Trademark Counterfeiting Act of 1984 is a United States federal law that amended the Federal Criminal Code to make it a federal offense to violate the Lanham Act by intentional use of a counterfeit trademark or the unauthorized use of a counterfeit trademark. The act established penalties of up to 5 years imprisonment and $250,000 fines, $1 million fines for corporations or other legal entities for selling or attempting to sell counterfeit goods or services. It increased such penalties for a second or subsequent conviction under the act. Here's where it gets a little bit crazy. Okay. The trademark infringement involves the determination of the probability of confusion by consumers between two marks, similarity of appearance, phonetics, and meaning, as well as channels of trade, direct competitiveness, strength of the famous mark, and evidence of actual confusion can determine trademark infringement. The remedies of trademark infringement include, but are not limited to, attorney's fees, destruction of infringing products, and any other materials bearing the infringing mark, profits obtained by the counterfeiter from the infringing products, and injunctive relief. We're not going to go through the history. And sorry about that. That's my dog. But here's the deal. What we are going to go through is what was the purpose of the Senate and House bills. So the Senate and House bills both aimed at accomplishing three primary changes in the law. First, creation of criminal penalties for intentionally dealing in materials that one knows to be counterfeit. Second, authorization for mandatory and virtually mandatory awards of treble damages and attorney's fees in civil counterfeiting cases. And third, authorization for ex parte court orders for the seizure of counterfeit materials when it can be shown that the defendant would be likely to attempt to conceal or transfer the materials. So what does that mean? In a nutshell, you can get criminal penalties against the party who uses your trademark if they know it to be counterfeit. Also, you can get mandatory 3 times the damages paid out to you. You can get 3 times the damages of what the infringer had actually damaged in its monetary value paid out to you. And it has to be as a result. As a result of the trademark infringement. No other way. And also, you can get authorization of an ex parte court order for the seizure of counterfeit materials when it can be shown that the defendant would be likely to attempt to conceal or transfer the materials. All right. Has anybody ever had a debt that got sold to someone else? If you can show, or at least give the illusion by a good argument, that the party might transfer the debt and sell it maybe to a third-party debt collector, they might try to burn the assets. You could get a court order to run in there with agents to go ahead and stop that party. Stop that party from being able to do that. That includes data files, records, internet communications, backdating, a whole list of anything that bears your mark I'm going to say it again. If the infringer has items, documents, records that bear your mark, you can get a court order to stop that fucker from being able to destroy, conceal, or evade having to be liable for those 3-time damages by damaging or concealing or hiding the very same assets that are infringing upon the trademark. If what I just said doesn't make your ears perk up, then I don't know what would. Because what I'm telling you is, hey, they got a court document with your name on it. Someone is getting paid in that courtroom as a result, and they are all colluding infringers. They must pay 3 times whatever they made. That attorney made $10,000 to take up the case. $30,000. I need that. Those documents, I need that. Taxpayer funding and all of the gains that the state would have made as a result. We need that too. It allows for the accounting to come to surface, and that court order for ex parte seizure will stop them from being able to hide the shit. You will get paid everything that transaction has made coming to fruition. Do not mistake it. You are reading this correct, and I am explaining it correct. Now, here's the deal. The Trademark Counterfeiting Act of 1984 made it illegal for anyone to intentionally traffic or attempt to traffic goods or services knowingly using the counterfeited mark, which is defined as a spurious mark and spurious designations used in connection with trafficking in goods or services. 2, identical with or substantially indistinguishable from a mark registered for those goods or services inside of the United States Patent and Trademark Office, whether or not the defendant knew the mark was registered and in use, and the use of which is likely to deceive, confuse, or mistake on the part of the consuming public. So that's what it was for the Trademark Act of 1984. I'm going to go ahead and tell you this ahead of time. Those items specified under the Trademark Counterfeiting Act of 1984 have been amended even further, and I'm going to show you now. These counterfeit goods include numerous things such as labels, stickers, wrappers, charms, cases, tags, and patches. Now, by cases, does it mean court cases? No, it means casings, like a Nike shoebox. So let's be clear about that. So it includes those things. It includes those things. But that does not mean that it doesn't also mean any other mercantile type of asset that would be using that counterfeit mark. The whole purpose of trademark infringement and its definition is to disqualify any competitor's ability to use your mark. So let's not get confused between the definition of cases, meaning shoeboxes, and the fact that it would not have the same effect on a case from attorneys using their commercial license to practice law and using your name as a trustee, directly competing with your ability as a trustee, which holds your intellectual property. Don't think that it doesn't stop that. The answer is it does. They would still be held liable for those 3 times damages. But let's keep going. Originally, under the Act, the penalty for being convicted for trademark counterfeiting was up to $100,000 and a prison sentence of up to 5 years, plus paying attorney's fees to the trademark owners. Here's the deal. Here's where the amendment comes in, because I started this article at the top talking about those 5 years, $100,000 and $1 million for corporations. But these penalties were later amended and called for a fine of up to $2 million and or imprisonment for up to 10 years, with large companies being fined up to $5 million. If charged more than once for the trademark infringement, individuals can be fined up to $5 million and or imprisoned for up to 20 years, while corporations may be fined up to $15 million. Counterfeiters of safety-sensitive products, such as pharmaceuticals, would get the maximum penalty set forward in the Act. Now let's talk about that ex parte seizure. One of the most powerful provisions under the Trademark Act of 1984 is the ex parte seizure. Under this part of the Act, an aggrieved party may seize the counterfeit goods, business documents, and machines used that the counterfeiter has without notice to the counterfeiter. The section on ex parte seizure amends the Lanham Act, creating stronger remedies in civil cases involving the intentional use of counterfeit marks. Trademark registrants may apply for an ex parte seizure through the courts without notifying the counterfeit party. The courts, however, will not grant ex parte seizures unless, and you can read it for yourself. But look at number 4. The applicant specifies the time and period the seizure will occur within the limited time frame. And 5, the seizure is not publicized. Five. The seizure is not publicized. Number 8, the person obtaining the order provides security to cover the damages the adverse party may suffer due to the ex parte seizure. All right. So I'm not going to go into any more. I'm just going to leave that on the screen and just finish explaining this. Very powerful tool. Someone infringing on your trademark can get their laptops taken, their system inspected, and you can get a court order for it without having to notice them. But don't be having a big mouth. Don't be running around, hey, I got these guys, watch this, guys. We're going to go ahead and we're going to run up in here and we're going to go snatch up their laptops. Don't do it. Just shut your mouth and get the goddamn order. You do that, mission is success. Mission is success. You don't even have to notice the counterfeiting party. We just read that. Okay? My source, Wikipedia. I was going to let this video out last week, but then I said, I don't know. You know, this is really, really cutting to the heart of a lot of stuff. Anybody that would like to come to the course, as usual, go ahead and read the description box of this video. You will find a link to my messenger. Do not send me messages through Facebook. Don't do it. I'm not reading them. You must become a contact on my messenger. It's a whole different fucking thing. Do not just send me messages through Facebook. I am not reading them. For some reason, Facebook isn't allowing me to read them. I don't care why. I have Messenger. hit me up on Messenger. Hit me up on Messenger. Let me say it one more time. Hit me up on Messenger. Because that's why the link is in the description box. I hope that what I showed today was fucking awesome. Because it's a very powerful vice. He who does not realize that this is a powerful vice, let's just throw it on the table. Go ahead and inspect it so that you can come to terms with the fact that it is a powerful vice. I appreciate all. Okay? I appreciate all. And again, if you would like to join the course and you actually need this information, give me a holler. I'm not going to be making too many more videos because that's why I have a course. I will be making a few videos. I try to keep it once a week, sporadically. Hopefully, you'll just join the course. All right. Talk to you guys later. Bye.